Welcome to the MIPLC Lecture Series. Initiated in 2005, the Lecture Series is a forum in which renowned scholars and practitioners from all over the world give presentations on current issues of innovation and competition. My name is Seth Eriksson, and I'll be the moderator of the talk today. I'm a program director at the Munich Intellectual Property Law Center, MIPLC. I've been the program director since 2009. I'm also a research fellow at the Max Planck Institute for Innovation and Competition. Today, it is my pleasure to moderate the talk given by Dr. Begoña Gonzalez Otero and Jörg Hoffmann. Begoña and Jörg will speak on legal, economic, and technical perspectives on interoperability, or how to gain normative strength via technical determination by law. Begoña is a senior research fellow at the Max Planck Institute for Innovation and Competition. Her research encompasses intellectual property law, where she has a focus on European patent and copyright law. She also has written extensively on software-related legislation and doctrines of law, law of the digital economy, information and technology, interoperability and standardization, many other things. Jörg is also a research fellow at the Max Planck Institute for Innovation and Competition. His research focuses on antitrust law, intellectual property law, law and economics, regulation of the data-driven economy. And that's what we're going to talk a lot about today. Jörg and Begoña, it is my pleasure to have you here. Thank you very much for joining us. Just like to get a few of the procedures for the talk cleared up before I give you the floor. As I mentioned before, we'll be having the chat function enabled. So if you have questions, please submit them following the talk given by Begoña and Jörg. I will then read the questions aloud so that when this is posted to YouTube later, people who watch after the fact will understand the question. So I'll be reading out loud, one of my favorite pastimes. I love to read the questions in Trivial Pursuit. And then I will not be giving the answers, however, Jörg and Begoña. I will only be reading the questions and they will give answers. We've planned about 40 minutes for the presentation and about 30, maybe 40 minutes for the Q&A. So we should be out of here by 3:15 Central European time, okay? If it's fantastic and we're having a lot of fun, and Bego and Jörg say, let's keep going, and the audience wants to keep asking questions, we'll go as long as they are willing to stay, but we're gonna shoot for a 3:15 close. Okay, so thank you. Without further ado, I'd like to hand you the floor, Jörg, and guide us through this very interesting area of law and technology.
Yeah, thanks a lot, Seth. Also, thanks a lot for the invitation, and thank you all that you are here with us today. We're going to talk about legal, economic, and technical perspectives on interoperability, or how to gain normative strength via technical determination by law. Today's lecture doesn't work. There we go. Yeah, on today's lecture, we're going to focus firstly we're going to set the scene by putting data interoperability into a wider context, also the data sharing and data access context, which is key to completely understand what data interoperability is all about. This will be then followed by an overview on then the interoperability itself and its technical, economic, and legal implication. Then we're going to do a check on the EU policy approach. We're going to conclude, and then in the very end, we're going to address this rather difficult question of how to gain normative strength. And we really hope that we then, go into a lively discussion and, answer all the questions that pop up at some point. So as a starting point, I think it's really important to bear in mind that data interoperability cannot be looked at independently. It is an essential part of data sharing and thus should build on the law, economics, and the technical prerequisites of digital data, data access, and the well-being of consumers and society at large. So the main questions when looking at data interoperability is how to reap off the benefits of increased data sharing and how to design the right legal framework. This is already difficult to assess because data sharing may cover a variety of modalities of data exchange between two or more parties. So for example, data sharing ranges from monetized trade to free access or exchange of data in turn for a service, towards legally mandated sharing obligations in order to tackle market failures. Data access may also safeguard the enforceability of other legal obligations. For example, information disclosure is key in antitrust proceedings. It maintains democracy, so journalists actually need access to information. It protects the data sovereignty of people by tackling lock-ins and safeguard data privacy and informational self-determination. And data sharing by itself may boost data-driven innovation and has direct and indirect welfare-enhancing effects. All of these examples include different public and private interests, exist in various different market settings, built on multiple technological developments and standards, imply different stakeholders and value circles, and also come with different legal frameworks pertaining to data access. So it is a really complex issue, and it certainly is quite case specific. And I think if you read the paper, you kind of instantly see that it is relatively hard to kind of get really the red line in it, but I think complexity is still key in order to address it correctly. Yet all of these different settings build on common economic characteristics of digital data. And this is also really important to have that in mind when we actually talk about the current policy debate or assess the current policy debate, right? So first, data are non-rivalrous in nature, which means that they can be used multiple times without getting consumed. So sharing of data generally increases general welfare. Here it is noteworthy that then to mention that there are certain positive network externalities and data-specific economies of scope and scale, which means that the more data you get from a lot of different sources, the better it is. And then also from a platform perspective, the more data they actually get, the better they can actually predict certain behavior of consumers or whatever, but in general, like increased data from a lot of sources increases welfare. So accordingly to the OECD, they estimated in 2015 an annual growth rate of 40% of for the big data markets. Back then, the global market for big data has already reached $70 billion US. It also assessed that the productivity efficiency will be accrued by 10 up to 15%. And they outlined that there are already existing indirect and direct effects in fostering social welfare. Another point, though, that is important is that digital data in general can be held exclusively, and thus, maybe depending on the case at hand, indeed, but generally are not considered a public good, right? And are therefore not prone to just investment-specific public good market failures. This is why also a lot of people actually from the economics are claimed due to the efficiency effects of increased data sharing, a lot of economists actually claimed for more data commons. So this was been done by Fishman and actually built on the economic work from Ostrom on general commons. I think here one of the difference, however, is that Ostrom rather built on kind of non-digital kind of so brick and mortar cases and non-digital markets that we are currently looking at, and also she does not build on relative anonymized markets that we are currently having in these cases. So here I think the case is different, but in general Fishman wrote a wonderful paper on that and actually claimed for more data commons. But I think it is extremely important that we also need to assess that there is still the risk of positive externalities of data commons that may lead to a reduction of investment, right? So we still have parallel to the traditional IP economics, this tragedy of commons considerations that we need to look at, right? So tragedy of commons relates to the fact that, I mean, if I share something and others can free ride on it, I invest a lot of money and at the end I can't really recoup it, I then lose my incentives to further invest in that. So this is still something that we have also in the data context, and we also need to be aware of that. And there are other negative externalities and costs. This relates to privacy, also algorithmic governance, where we are getting nudged into certain behavior. If we want to get certain products, we get targeted advertisements, all of that somehow changes us in certain ways. We also need to look at security risk if sensible data is implied. And also, I mean, we have competition issues in here as well. And all of them are typically not internalized by firms. Next point is that data is manifold and can be used in so many multiple ways. So this increases not only complexity within a legal sphere, as there are so many overlapping different legal fields. It also makes an appropriate balancing of different public and private interests extremely difficult. So the general and on top of these, all these interests are also embodied then in a constitutional framework and reflect on fundamental rights. And this constitutional framework for data governance framework cannot be overseen and also creates challenges as constitutional laws need to adapt to a digital era. So ultimately, this topic needs to be seen in a much broader context. It not only implies questions of how our economy should look like and how economic growth and international competitiveness can be accelerated. It hits the core of our societal perception and the way we see ourselves as a digital society. The fifth point here is that there are different attributes of data, and we somehow have something that actually relates or is something that we relate to as a taxonomy of data. And depending on these certain attributes, the law sets out certain legal obligations and rights under data governance frameworks. These attributes are, for instance, the aggregate state of data. So it matters whether we have inferred data that stem from machine learning applications, for example, or we just have some aggregated data or even raw data. Then the information embedded in the data is extremely important. So do we have personal information? Do we have non-personal information? Does the information actually entail a trade secret? Also, the factually exclusive holder of the data is extremely important, as it may yield certain competitive advantages, right? So this is what we currently see in the Digital Markets Act, where platforms are on the radar of the legislator and the regulator, as a lot of data transfers a lot of competitive advantages, right? So this is also what is important. And labor put into the data is another point that is important on the current debate of co-generated data access right. That is quite important in IoT devices and in typical B2B scenarios. Then 6, real-time access to data is key for a lot of current digital-driven business models. So this is also what is extremely important to note, that we kind of need really instant access, which has a lot of economic impacts in these cases. And also from a legal perspective, you might need to think a bit out of the box here. And lastly, I think there are a lot of other issues. For example, the information, if it comes to a transaction of economic agents, as we have information paradox, and the incomplete contract theory that we need to keep in mind. The information paradox is simply the fact that once I deal with information and I disclose it and the other one knows it, the information loses all its value, right? And Bergman and Bonatti wrote a wonderful paper on potential ways to kind of tackle that issue. And under the incomplete contract theory, it is important to kind of assess that any licensing agreement on data that goes with a constant flow of data and goes with all that that actually implies a lot of different data. We always have that issue that at some point the heterogeneity of data and information asymmetries in terms of what data is shared, whether the quality of data is there or not, creates a lot of creates a lot of issues regarding to behavioral issues, as in these cases, people might not even enter into a contract because they simply don't trust each other, right? And as there are always these principal agent issues, and I don't know whether I want to share data and I get exactly the data that is best, that I want, that I need, may actually hinder people to enter into contracts. And this is exactly what brings us to the next slide, where we need to look at potential market failures. And this is, so economists actually define market failures as situations where the aggregate private welfare of firms and consumers remains below the total welfare that society as a whole could achieve. This occurs when the incentives of private firms and or consumers make them behave in ways that diminish overall social welfare. So market failures typically include monopolistic market failures and extends to other sources of market failures, such as externalities, asymmetric information, and missing markets because of high transaction costs and risks, or like your behavioral issues. If it then, in the data sharing context, I think here potentially all the different sources of market failures may actually take place, because under transaction cost considerations, we have interoperability and we have the information paradox and then complete contract theory that actually increases the transaction costs enormously, right? So this is also why a lot of people actually thought that maybe, same consideration as in IP constellations, the implementation or just the introduction of new ownership rights would help. We personally think, no, this is definitely not a right way forward, but it has been discussed and it's currently also being discussed in the US. The second one relates then to behavioral issues. We of course see that lack of trust, or simply there is no demand, right? Because what we still need to bear in mind is that a lot of SMEs simply are lacking the infrastructure that is needed to actually make use of all the data. They may actually just have, there is a lack of expertise in using it, or maybe they simply just don't want to use it, or consumers are prone to these inertias. So here, I think a more inclusive policy is also needed. The next thing is, of course, the information asymmetries that we actually looked at. Here we have this traditional principal agent issue, where I am not aware whether, I get the best data and also the data that I actually need. So here, and ultimately, we have also data-induced competition concerns. On the one hand, of course, on the exclusionary abuse constellations and considerations. And this is also what we currently see in the platform regulation debate. These digital conglomerates get access to so many different data. They can create profiles. They have such a superior knowledge about ourselves, about potential other ways how they can improve their products and improve also their line of business. And this is also what in the very end, we see with the creation of digital ecosystems, all of these get the possibility of then getting entrenched in a lot of different markets. And this in the very end increases then this incontestable knowledge that they have. And this may of course lead then to potential foreclosure strategies, the so-called enveloping strategies of the firms. And here we need to look at that also from this foreclosure perspective, because they know more than anyone else pretty much. And on the second hand, there is exploitative abuse constellations, what we see with the Facebook case, for example. Here it's all about Facebook's offering us certain services that maybe we don't really want, and this is actually intrusive and is actually infringing our right of informational self-determination. And here, this could actually be a coerced version and something that tantamount to an abuse of dominance in certain circumstances. So depending on the market, and this is also key here, there may be market failures, but the question is, so how to effectively remedy it? And this is exactly what we need to do here, that of course we have the issue that there are hidden costs and challenges of data sharing. We have welfare enhancing effects of data sharing. And I think the two questions that still remain is, do we only go with market failures, or is it also something that we rather think of kind of a public utility form of regulation that increases data sharing in these contexts? And in the end, it's important to also know and how to define the right balance between excludability and access. And I think these are the two key questions that we need to ask in these cases. And this is also what the current policy debate is focusing on. So yet there are also already existing data sharing obligations, not only implemented into the law, but also that are currently being discussed on a policy level. From a competition law perspective, we saw that with the introduction of the 10th Amendment of the German Antitrust Code, for example, we now have a data sharing obligation for these undertakings with paramount or with significant with paramount significance throughout the market. It's a rather long term, which is extremely complicated, but it is pretty much the digital conglomerates and the big techs that are now on the radar, and they are now obliged to share the data in certain circumstances. We also see that paragraph 19, so the general abuse case is also kind of has also been adapted, and most importantly also that is paragraph 20 under the concept of economic dependency. We see that even more data can be shared under these traditional thresholds that we were looking at. Regarding data protection laws, we have the data portability right, unfair competition law. Joseph Drexel wrote a wonderful study on it, on IoT devices from a B2B perspective, where it is really key to kind of have these access rights for certain people that are actually involved in the kind of for certain people there. Then we have consumer protection laws that are relevant, and economic regulation. Economic regulation, I personally think the DMA rather gets better subsumized in here than direct competition law tool. I think we can't really go into too much detail here, but yeah, we have economic regulation, platform regulation that we are that I already mentioned. We have sector-specific regulations. So, for example, in the car sector, there is repair and maintenance information. We also have new laws there, where we have a really kind of like a broader scope on the aftermarkets doctrine that has never been there before. So there we also see the tendency of sharing more data in order to better reap off innovation in these contexts. In the payment sector, for example, we have two quite interesting access regimes that should enable more innovative payment services, for example. Also in the contract law sphere, there is the Digital Content Directive, where I get a right after termination of the contract to actually get my data ported, right? So this is also what we have. Plus we have private initiatives. And in the very end here, this is Gaia X. These are also other forms and European data spaces that we are looking at. So what we see, yes, the lawmakers are active, the policy debate is really active, and still the question that came up for us is, all right, how is interoperability actually assessed in these cases? And how does it actually shape any data sharing obligation, right? And this is then what kind of triggered Bego and my interest, and we thought about, okay, let's look at that issue. And this is why I also now hand over to Bego, and she will introduce you to the topic of, or the conundrum of interoperability, as we just put in our outline. So yeah, Bego, the floor is yours.
Thank you, Jörg. Can you just pass the slide? Thank you. As you can see, we needed around 20 minutes out of this 40 just to set the scene. So that also shows how complex this is. It's not, I mean, it's not even a constellation, it's a universe. And that also explains why when we address these other parts, the technical, the economic, and the legal part, it increases. But I think it's really important to understand that we're facing something that has many layers and many connections, and many of the problems are beyond to be at the interface, are also at these different layers. When we go into the technical part, and this is also what we're trying to show here in this slide, to all of you, where you see all, when it looks at interoperability, all these boxes. I'm not going to go into a lot of detail because, it's the same as we know that for interoperability, we don't have a clear legal definition. We provide a definition, a kind of common understanding definition in the paper, that the ability of a system, a product or service not to communicate and function with other systems, products or services. So communication here is key. What communication means is also important. So that I give, but I also, the receiver understands what I give. So when we look at interoperability from a technical point of view, and this is what we want to do with you today, is to give you some examples, some real examples, so you can see that it's more pragmatic. Because I think that one of the lacks that we might have in the paper, and it's because we're legal scholars, is that we don't include pictures. Now, my brother also always says that. I mean, it's very boring. It's always, you know, text. So we're going to give you some real examples so you can visualize where the problems come from. We have talked about, and many of you probably know about this structural, from a connectivity problem, or these structural levels, syntactic level, all these layers from a technical point of view of interoperability. It's everything it's explained in detail in the paper. We focus a bit more on the semantic part and how important it is, but also I will show you that syntactic and semantics are also interconnected. And normally, the main enablers for achieving this type of interoperability, as you can see on the slide, and as we say in the paper, are either APIs, these application program interfaces that have a long history. No, there is a ongoing soap opera about that now before the Scotus in the US, and data standardization, where actually Michel Gall has written a fantastic paper on. So we know that APIs are a type of interfaces that are functional. It's a type of software interface. I will go a bit later on what are the problems from an IP point of view on that. But it's important to understand that when we're talking about APIs, we need to differentiate two parts of APIs. One part will be what it's the specification. So if you have in the back of your head the Google Oracle case, everything is about that, although we think now everything is turning into a fair use case, and it might be decided as a fair use case, not as a scope of copyright protection case, which was the interesting thing at the beginning. But when we look at APIs, we have specifications on the one hand, and these are declaring code, so it means that they don't make the computer do anything, they don't execute anything, they don't instruct. And this is what it's really important from a copyright perspective, while the implementations are these set or step-by-step instructions that use, and here comes the complexity too, directly or indirectly, in a computer, they instruct the machine to do something. So here we have the executing part. Then from a data standardization perspective, we know that we have these data formats and these data models that I'm going to show you in a minute a bit more, where in data formats, we normally focus more on the syntactic level because they are more like the bricks of a house that we want to build. But there is a certain level of semantics that is also necessary. And in data models, we have the combination of both. Before going into that, also just a couple of notes on competition law and economics. When we think about interoperability, probably you all have this traditional double dimension perspective. So these either intra-brand or inter-brand competition. And when we talk about horizontal interoperability, we're talking about intra-brand competition, so competing products, services, platforms. And in this case, we normally, from a European perspective, can recall of the McGill case, the IMS health case, so refusal to deal cases. There might be one exception because, as we're not the only ones, I mean, there are many scholars who also think that Microsoft, it's a bit of strange or rara avis, so a kind of exception, because namely under the theory of incontestability or the valency of interest theory. And then we also have SAP cases that that can also fit here, because although the rationale it's different, no? Because the opening up stems from a voluntary legal obligation in the standard setting organization process. And then the vertical interoperability, where we're talking about the interoperability of interbrand, so a product, service, or platform with complementary products, no? And here, normally EU law or EU competition law and the sanction facility considerations, and also interoperability information that might have to be disclosed. No, it's what plays a role. It's still to be seen how this plays in this ecosystem and platform regulation, but I will leave that for later when we analyze or check the EU policy. And then also from a legal, perspective, we think that it's also important to take into account that when we're talking about legal considerations, interoperability can be directly addressed by the legislator in the course of what is data governance, so direct regulation. And that's something that we refer as public law approach. And we will go into that a bit later also when we talk about the normative strength. Just keep it in the back of your heads. But there are also other ways that interoperability finds its way in the legal sphere. However, it's normally via, as your point before, via the access to the portability right itself, which take a more private law approach. And normally such rights entail certain technical interoperability obligations in order to perform. So if you think about portability rights, or if you think about access regimes, sometimes, and not all the times, there are certain requirements, technical requirements. Sometimes there is just a call to general interoperability. So that also gives us certain tips. And what we also can see is that the constitutional legal framework requires this balancing of interest that we also see reflected in the intellectual property and trade secret regimes. So if you can move to the next slides, Jörg, please. Okay, so here, just going into data, no? So, I mean, besides what we need to do is it's first define what we meant by data. No, that's so what type of data we're referring to. But when we look at the format, so more technical aspects, normally data can take three different approaches or three different classifications. One is structured data. And in these cases, the data it's in a format that it's tabular and strict, and data records form are a predefined set of files, as you can see here in the comma separate values, not CSV. It's very interesting to understand, especially from a legal point of view, I think, what are the meaning of all these acronyms, no, of all these names. CSV means more or less that comma separated values, and that's a rigid tabular format, as you can see there, no, year, model, make, description, price, and that's one. Yet, what is interesting is that this type of structured data formats like CSV or like in databases SQL or even spreadsheet files are not fully standardized. So they are strict, they are rigid, there might be strict norms, but still they are not fully standardized. When we look at semi-structured data, normally in these cases we have a combination, no? It's a bit of a hybrid. That's what it's semi, no? Like like milk. Because here we have this mixing structured content and the potentially unstructured text with kind of a range of data attributes that need not to be defined ahead of time. And this is, for instance, what you can see here in the example of the JavaScript object notation, where what we have is a hierarchical shape with a range of data attributes. What is interesting in these two levels is that the file format only specifies a syntactic layer on the way that information is represented. So to make use of the data, it's necessary to use its schema, no? So some fields and attributes, or we also need to know what are the constraints of the data value. So, and this goes a bit beyond what it's a mere syntactic level per se. Can you move to the next slide, please? And then we have an example of what it's unstructured data per se. So if you can see on the left top, there we have an image, and out of that image, there are, I mean, all these objects that we have there, they can be considered as unstructured data. Why? Because they do not fit in either of the previous categories, so structure or semi-structure. And normally it's because it comprises plain text in natural language or multimedia data, such as images, sounds, videos, or other arbitrary binary data that it's much more difficult to put into these other formats. The truth is that, and that's also what we have seen, there have been attempts at categorizing it. So some of unstructured data at different levels. We have some sectors such as the intelligent transportation systems or geodata. But the truth is that it's very complicated to categorize these, because the data formats and even the data models that are used to represent, store, and exchange data are extremely dependent on the kind of data used. So again, this is a hurdle, no, an obstacle to overcome. Then beyond syntax that it's given by the file format and the schema and constraint that are given by the schema annotations when they are available, they are not always available. We also need to understand the data needs to be interpreted with respect to a specific semantics, as we said before. And this is what gives the meaning to the data fields and the attributes. And this is what it's called sometimes data vocabulary or data repository or even a data dialect. No? And we have some application areas where these dialects have been de facto standardized. But again, this is the important thing to remember, de facto. And for instance, when we think about GPS and the exchange of GPS traces, the de facto standard is the XML dialect, but this does not mean that its adoption is completely widespread for different reasons. First, it's because it's de facto, so it's not mandatory. There might be competition reasons, there might be innovation reasons, etc., even technical issues. So not everyone has the capabilities, or you might want to look for a different option. And on top of that, when there is not a prior dialect or a semantic repository, normally the ad hoc dialect, so the creator of the new data model is the one that should come with this repository or this semantic dialect. Then when we look at data models, what we have, it's, as we said before, something that is a bit more complex. Here you have two examples of logic data models. But what is important here to remind is what we said also in the paper, that we're talking about like an architect building plan instead of types of bricks. So here they have higher levels of abstraction. And what is important is because the abstraction is higher, the levels of semantics, so what's actually the real meaning, no? These dialects are even much more necessary. And then when we look at APIs, we want also to include here, and what you see here, it's a client API request. And this is a real from an example where they are requesting data from a system. In this case, it's from a Mongo database. A Mongo database is different from the SQL type of database. And to put it simple, in these type of databases, the data objects are stored as separate documents inside of a collection, instead of storing the data into the columns and rows. That in an SQL, it's the typical thing. And this is a data request coming from an example that the authors of this paper ran a case study on a service broker in a smart city, and in particular sensor data. A service broker is a server that receives all messages from the clients and then routes the messages to the appropriate destination clients. And what they did is to implement these for control of utility systems in urban environments. They use a REST API, and that's how you do the authentication, connecting to the database. And you need also to go as a client through an SSL, so it's a certified type of data file to secure the access to the API. And this is what nowadays provides security standards for sensitive data transport through the internet. However, and this is also what we think it's interesting to keep as an example, is that APIs, the calls, they do not use authorization for getting sensor temperatures or measurement data. And don't forget about the case that we're talking here. So any user knowing the API URL could get those measurement data. And in the future, what they said is that the levels of security could be based on the same SSL security authorization using two different levels of authorization. No? So one with a client username or an email and password, and secondly with an API key. But still, I mean, this is very recent from 2018, and this is, again, one of the other issues that we're facing. I hope that at least the technical part has been clarified. And now if we move to the next slide, we can talk a bit more about the APIs part and how, before going into that, we can go into the economics part, sorry, yes. And then we will move more into the IP and the other legal part. Jörg, the floor is yours, thank you.
Yeah, thanks. So yeah, looking at the economics of interoperability, I think it's key that we always keep in mind that a starting point always has to be that a lack of interoperability does not automatically constitute a market failure, or it can be considered a public utility case, right? So According to the traditional competition economics literature on standardization, and this has also been translated into relevant case law, there can be monopolistic market failures. Here we need to distinguish between, of course, the vertical and horizontal interoperability. We already had that, and Bego outlined that. I think horizontal, from that perspective, it actually quite makes sense, because we still think that dynamic competition is key. We simply don't want to have some competition on price, because entry into the same market would then end up by just homogeneous products. This is clearly what we typically do not want from that perspective. And yeah, it's interesting also in the DMA that they are currently considering maybe even more entry in the same market. So here we kind of need to have more the focus on. From a vertical perspective, typically what has been said is that the aftermarkets doctrine has been quite restrictively applied. System competition is typically enough. Firms really do know what, if there is enough competition, whether they should come up with open or closed systems, right? So if now the demand side is really wanting some interoperable solutions, then they typically provide it. So here we always kind of have that that issue of, okay, I mean, we only need to look at cases where we have exclusionary abuse cases. I mean, sure, with Microsoft and the theory of contestability, it looks different. We always think that more entry into any market kind of might tackle these paramount kind of unbeatable power of these economic agents in these markets. Maybe yes. I personally rather doubt it. I also think that here the infrastructure that is needed, a lot of other things that is needed is super key. And we are in markets that are pretty much determined by really, really strong network effects, right? So here, sure, caution is needed, but in general, yes, if there is an exclusionary abuse case of a dominant firm, yeah, we get access. The other case would be natural monopoly. So we saw that in the telecommunication sectors, and here there are economic efficiencies due to monopolistic standards. So if it's a public utility, we maybe even need a monopolistic standard because everyone just simply needs it. Farrell and Skimrow quite nicely put out the 4 different paths to interoperability that related to standard wars, the unilateral imposition of a standard of a firm, then the collective standard setting. And they also looked at adapters and converters. And I personally think that this is, again, what we can look at with our APIs currently, right? That we have a lot of plug and play, or not a lot, but we can at least think of plug and play APIs that may work as adapters in these cases. So here, attention, indispensability criterion under the traditional 4 requirements that we know for under the refusal to deal cases. The Cour de la Concurrence in France actually held in the Apple Fair Play case that if there is an adapter in place, maybe we don't even have indispensable information anymore. So here this also has to be kept in mind and also be assessed. Then looking at standardization, sure, interoperability is achieved by standardization. Here it is extremely important to know that a one-size-fits-all approach does not really help. We have different patent portfolios, we have different standardization strategies in place. Markets work so differently that in the end, maybe, yeah, a more nuanced approach would be better. We also have then other issues with decentralized standard setting. In most of the cases, so we have still the investment incentive issues, as the private incentives to choose a certain standard may not align with the social benefits. So this is also, so yeah, a firm will be typically not be able to internalize all the positive effects that an open standard may have for other firms and consumers. And therefore, yeah, the market may end up with a fragmented standards equilibrium. That means we have a lot of different standards out there and issues if it comes then to fully reaping off the potential of also data sharing. There are also certain knowledge problems. I mean, yeah, the development of certain standards, this is also what Bego just showed if it comes to data models and also the APIs and these certain kind of structures where automatic information processing and like maybe put in simpler words, establishing a system where everyone understands each other, where everyone is pretty much aware what the other one is actually thinking, what he is kind of putting in there. And in order to make that really effectively usable, it's extremely complex. And of course, there are people that speak different languages, and there are different architectures, there are different houses. In the end, everyone wants to have somehow the same thing. So I think here, that is also a knowledge problem that is out there. Here, I think in general, also it is a dynamic issue that takes a lot of time. And I think in these particular cases, we also need to have in parallel a continuous stream of getting a lot of then further work on standards. That is also key. Then the path dependency effect. Interoperable standards are typically characterized by positive network effects. That means the more people that actually use the standard, the better it is. This leads, however, to a first mover advantage and aims of firms to achieve a critical mass with their standard, right? And this in the end may lead to a standard lock-in and thus the phenomenon of an inefficient market selection of technologies through dynamic effects. That means in the end, the one that is first, but not even has the best standard, might in the end win, right? So this is a bit tricky. And of course, this entire issue is accelerated by standard wars and the possibility of bundling strategies of bigger firms in order to establish a certain standard. So what we see is, according to the financial strength theory and also the portfolio effects theory, that firms simply provide you with products below the marginal costs, with services below the marginal costs, in order then to establish a certain standard. And then at some point, gain a monopolistic position and of course, raise prices. So here, there's also an issue. And I personally think that Microsoft, with all these big techs kind of opening up their data, could be an issue. We need to look at it. I'm not sure, but yes, I'm also not so happy with this entire development from that perspective. Yeah, and in the very end, I think we also have to keep in mind that static solutions for a dynamic issue is always something that we don't want. We don't want to end up with, I don't know, what we saw with messages that don't really kind of get any innovation, right? So having a standard on writing text without smileys, without all of these, might just simply not what consumers in the very end want. So what we need is, of course, a kind of dynamic solutions and not really static solutions. And there are always these issues with centralized standard setting. I think it's a better way forward. We have experts on the table. We see that with ETSI and a lot of these standardization organizations, but it's still not really and it had still issues with patent holdouts, for example, a lot of other cases, but I can't really go into detail in here. So what is special if we talk about data interoperability? I think it is special. We have, and this already outlined, the tendency that increasing welfare due to increased data interoperability takes place. Sure, there are these negative externalities, investment incentives, and all of that, privacy, but in general, this tendency is there. Yet, and I think that's an extremely important point, we have vertically existent data standards, and we need a horizontal solution, right? So we have sectors with specific data, but we actually see that making use of a lot of different data from a lot of different sectors might be welfare increasing. So here, I mean, this, of course, it's also not kind of a silver bullet. The more data you get, the better it is. They need to be correlations in there. We also kind of have exactly these correlations in there in order to make better use of the data. But in generally, vertical existent standards need to be kind of harmonized on a horizontal level. That's super tricky. So what we need is an open platform approach that supports multiple applications, domains, and cuts across silos, right? Another thing is we need real-time access. So, and of course, we have the trust issue and the transaction costs. And by actually establishing interoperable systems, without having a lot of upfront investment in the very beginning, it is better. And it also increases then, I mean, the trust issue. If I know that I get high quality data, because I simply know that this is the standard that everyone uses. I get the information that I need, and I simply can make something out of it instead of getting something that no one really knows whether it helps or not, right? So here, this is also it. And the solutions, I mean, that we're looking at, I mean, from a technical perspective, open APIs is key. Whether they work or not, it's a bit tricky. We see that in a couple of sectors. And also, I mean, from a legal perspective, what can lawmakers do is that, of course, we can actually open up API specifications that is needed plus metadata in order to just understand what the other person is actually talking about. It is like a kind of translator that I give these people. And with this translator, they can actually kind of understand what the data is all about. So this is also extremely important. This happened in the PSD2 and like in this sector. And what we also need, we need new institutional approaches, right? So Gaia-X or the federal data clusters in big data banking, it's fantastic. Personal information management systems, I see a lot of potential. It is a hybrid, they offer just private solutions maybe to that issue. And then, yeah, just very briefly to the legal framework. I mean, here what we did, we looked at, so what role should a legislator actually have and what did he actually have? We looked at all the existing market regulation that is out there pertaining to data access regimes and looked at data interoperability and the different provisions. What we saw is that there are different degrees of interoperability, starting with just a general ambition of saying, yes, I want interoperability, towards maybe, yes, the data format. So can it be PDF? Can it be JSON? Or can it be like whatever standard there? The metadata, towards a third degree, then the APIs. So this is the tool that I need to kind of get the data transferred. And then even the fourth degree, and this is something that we consider the kind of most valuable, most important one, is this kind of data semantic data model harmonization, where they actually outline what data or how you need to save specific information and what information needs to be contained. And by doing that, it kind of enables, and this is what we see in the clinical trials regulation, for example, with certain information that is needed from a certain aspect, and this actually makes the reuse of data much more easy. Yeah, so just maybe to wrap up that quite briefly, there are different regulatory approaches chosen by the legislator. We saw regulatory self-regulation, so we kind of left it to the private parties, towards predetermination by the lawmakers. So we kind of really assessed how it really should look like, right? We have a timely dimension. We see that luckily the lawmaker kind of changes also with technology development. So now they address APIs, which is good. They reflect on different levels. So on a horizontal level, we always see the least degree of interoperability. So this is, for example, the GDPR that goes through a lot of different sectors. And here, of course, maybe they can't really provide that because there's already a lot of fragmentation and different interests. On a vertical level, so speaking of the sector-specific level, we see a high degree of interoperability. And here, of course, there's the effect of positive spillovers. And also what is important is that the taxonomy of information is extremely important, where we see that high social value information leads to actually a higher degree of interoperability, whereas private data and some other data is not really subject to it. Bingo.
Yeah, sorry, I was muted. So maybe because of time, I'm gonna jump on the, I think it's best if we jump and skip probably the IP and competition part on APIs, because everything is reflected on the paper, Seth. I mean, because I think we're a bit over time.
That sounds good. Don't feel rushed, but that sounds fine with me, whatever you think.
Yes, because I think it's much more interesting if we move into the policy approach and this normative strength part. So just wrapping up our conclusions, just a big showing of what has happened with the EU policy approach, or what is our view on that. Taking, Jörg, if you can move into that slide, that will be great. Thank you. So, because here what we can see is that, as we have said, the Commission in the communication identifies, we think rightly, probably we all think rightly, the lack of data interoperability, but also data quality. What we still think is that the strategy is not very clear on what is the role that the legislator should play. Because on the one hand, the strategy foresees no overly detailed, heavy-handed ex-ante regulation, so no command and control regulation. including also interoperability obligations. But on the other hand, the Commission also stressed the need of a legislative framework for establishing interoperability. So it's a bit of a contradiction at a certain point. And accordingly, interoperability requirements and standards within and across sectors should be a priority. And of course, I mean, I think from the economic reasoning, Jörg already outlined why it's that important, and that makes all sense. And what they said is that this should be achieved by strengthening governance mechanism. Yet, so does such a strengthening of governance mechanism now relate to command and control, or to regulatory self-regulation, or to something else? It's something that still we don't see very clear. Or whether we should follow an horizontal or a more sector-specific approach. I mean, it's something that we think it cannot be still concluded or taken as a conclusion, no? From this strategy of the Commission. And even if we think about these different legal proposals that we have right now on the table, going from the DSA, so we have all these acts, no? Digital Service Act, Digital Governance Act, the Digital Markets Act, that now it's on the, so it's the one that it's the heated one. But we also have an upcoming Data Act proposal that probably will hit us after Easter. And we think still it's not very clear. We see that in some cases we have an interoperability ex-ante obligation. In others, it's taken as a remedy, but how it should work, it's still not clear. So we think that the Commission might be heading into the right direction, but as we said, this matter is so complex that it's not so easy to delineate, no, and to see, okay, this is the strategy, this is the way, just push and go. And this move us to a set of preliminary conclusions that we can show you on the next slide, where what we actually think is that, well, interoperability or just untangling, no, or demystifying the role of data interoperability here, it's a Sisyphus work. It seems that it's always going and ongoing. But on the other hand, it shows that understanding the technology is key. And this is because interoperability is becoming a main feature that not only defines the scope of a right, such as private rights, such as the access right or portability, you know, but also itself, it might already shape data sharing and how it happens. And what we also have seen as a preliminary conclusion is that technology might already be governing data sharing without legal intervention. And if legal intervention takes place, however, it might not only affect the efficacy of the right itself, but also affect the effective enforcement of such rights. And this is really important because thus interoperability might become another example of less is code, it's law. And that's also why we outline that interoperability should not be used as a goal, but as a means to an end. So this means that pre-designed data interoperability by default is indeed, or could be indeed, a key enabler for data-driven innovation. This, however, comes also with the caveat or adverse effects of a too high level of data interoperability, because that might have impacts on how competition takes place, or that could also hamper innovation. And this not only relate to negative effects of data sharing itself, because as also Jörg said, I mean, there are big, vast information asymmetries, but also we're talking about privacy or data-induced competition concerns. And of course, it also relates to a potential hampering of innovation with regard not only to data, but also to APIs. And also, well, I mean, with regard to IP, we haven't got into that, but as I mentioned before, we still need to know what will happen with the Oracle and Google case, but our fear is that it turns into a fair use case. So in any case, or copyrightability of APIs, we know that it might directly affect competition policy in software-dependent markets, but we still need to know what will happen in the US. So having all these in mind with this view, it's turned to Jörg to wrap up and just kind of try to open up the discussion, telling or explaining you how we think we could gain some normative strengths. No? What do we mean when we refer to public law approach and so on? So please, Jörg.
of discussion. I think we see it in so many different areas of law currently, and also from a legal policy perspective, that sure, how can we actually get and gain normative strength? Here we have a relative vague concept of interoperability that comes with a lot of different degrees, that actually comes with a lot of different market constellations, and also from an economics perspective and a technological perspective, it is difficult. We think that, I mean, a hybrid solution toolbox addressing these different levels, also the economic level, the technological level, and the legal level somehow, is key, because here, yeah, technology, as already outlined, can actually play an important role if we talk about plug and play APIs, for example. But yet flexibility is also quite important, right? So as just mentioned, dynamic solutions are still relatively important, because of course we don't want to end up with a standard lock-in and kind of have the same situation forever. If it then comes, of course, with a public law approach by better outlining it, and this is what we, for example, have seen in the PSD2, here we have a parallel system where the access right is implemented in the right of obligation of a bank towards the customers. The bank is obliged now to open up the accesses in order then to provide a third-party access that then can actually use the data and then offer specific services. On top of that, we also have certain obligations, and this is what we kind of see in a public law approach. We also have that within a public governance regime. So kind of the delineation of private and public laws is somehow obviously blurred. But here with the public approach, we kind of outline certain minimum standards that the bank actually has to comply with. And by doing that, we have the public enforcement advantages, and we decrease transaction costs if it comes to enforcement of maybe not having of the certain right that I want to use in these cases of getting access. We can better address behavioral issues. I think that's also quite important. So if, for example, I am not happy with any digital payments, I simply don't really use it. And I mean, the law can't really make anything against it, right? So even though they want to tackle that, I think still having kind of a good public enforcement body in here might actually help to overcome that, because then we have the standard, we have the third parties that get access, and we can simply or better actually target consumers. And yeah, in the very end, by opening up metadata and kind of have these institutional approaches in these particular cases, so Gaia X and also other hybrid models, we might come up with better tailor-made solutions and yeah, hopefully get more welfare for consumers and society overall. Thanks a lot.
Wow. Thank you very much for that tour de force. It is incredibly impressive how you managed to give such an overview of so many different topics in such little time. Thank you for doing that. And if I read the paper, and I think the really only part that isn't covered in your presentation, or that wasn't covered, is predominantly this IPR section of the paper. So thank you so much. And I highly recommend to everyone who's here with us today to go download the paper and read it. It really gives you a wonderful overview. And I'd like to open the floor to questions, again, using the chat function. I'll be monitoring it, and I'll break the ice with a question or comments of my own. Here you can see how you can contact the authors of the paper, Jörg and Bego. Yeah, as I was mentioning to you before we even started, it's not my area of expertise, and I felt immediately overwhelmed by the level of the technological aspects of the work that you've been doing. And I think, you know, that's highly impressive. So one of my questions relates to a lot of this being like just a multidisciplinary, interdisciplinary challenge. And I know that you did this paper kind of grew out of a workshop where I think you had IT experts involved in the workshop, and correct me if I'm wrong, and what that conversation was like with them, and whether you think that we need more law attorneys with these types of ICT backgrounds, and if we need more IT ICT professionals with that when they try to have interoperability considerations by design, or privacy considerations by design, right? Instead of just privacy by design, kind of making the distinction between interoperability as a means to an end instead of an end unto itself. You just have considerations, and those considerations could be speak for more interoperability, and they could speak against interoperability in certain cases, depending on what the constellation is, which makes it highly complex. But just because things are complex doesn't mean we run away from them, right? So I have these types. This is one question I had, and then the next question I had was relating to what you deem to be perhaps the most important level of interoperability considerations, the semantic level, and that second question being, you have the considerations that should shape policy around interoperability, and the pros and cons, for lack of a better terminology. And I wonder, at the semantic level, it seems like there might be the most amount of room for interpretation or different types of innovation and how to organize. And I'm not sure I've even understood the semantic level, to be quite frank, properly. But if you have this at that level, there seems to be the most room for interpretation or creativity, right? And if you try to get into an operability standardization or interoperability considerations by design in the semantic level, that you see a higher risk of a heavy-handed regulator at that level, as opposed to the first level of just, we want to have interoperability. It's a good thing to have occasionally. So those would be my two questions to start us off.
You want to start just with a reference to the workshop, because you were actually the person who was actually there. I mean, I was.
Yeah, sure. I'm happy. I mean, the workshop, I think it is clear that there are vast information asymmetries, or put in like simpler words. At some point, we were not really able to understand each other. And I think this is a huge issue, right? I mean, sure, interoperability is nothing really new, right? Like, it's an old thing. We always had it. And I mean, also, yeah, what is really new? That is, I think, the question that has to be asked in that context. But I personally see it extremely important, as it also creates also a lot of legal impact, kind of having now a proper understanding of maybe how an API works is really important, because in these cases we can already by design really tackle things, and a judge or any kind of person, a regulator, needs to understand whether any application works or not. And I think currently, I mean, if we have certain experts in the Cardinal office, for example, also on the legislative level, but what is extremely key is that there are certain also externalities that come with the use of technology, like APIs. What we haven't mentioned is that, I mean, by opening up these APIs, I also kind of can track what the other party has done, right? What data they accessed, how many times they did so. So this is also kind of a source of knowledge, right? So from competition enforcers, this is key to kind of have an understanding of what is actually able. And having these people, of course, like in the workshop, it is difficult, but I think it is really important. And kind of getting a better understanding is something that we should definitely do, also with regard now to the DMA and the Digital Service Act, where obviously technology creates a lot of new tensions and a lot of potential of, yeah, also harming consumers and society overall.
Yeah, I mean, if I want to add something, I mean, I agree fully with Jörg, but I also think that, I mean, maybe what we're failing at is that this interoperability between the technical or the technicians and the lawmakers, no, kind of, as we said, no, it's about communication. And sometimes it's because we're using different languages, and it's very humane. But we have seen that it has, I mean, it's happening in other sectors. I mean, we are talking about the APIs here, but the OBD port, it's another example in the automotive sector where incredible things are happening. The PSD2 also with, I mean, with these different approaches, with these regulatory standard, I mean, it's also moving into that direction. So we think it's possible. It's a matter of effort. No, it's a matter of wanting to tackle the issues. And it doesn't mean necessarily that as a lawyer, you need to learn how to programming or learn to, I mean, to learn a lot of technical stuff. You need to be able to understand it. And it's the same as when we were talking about software protection or, I mean, anything. I mean, if we start saying that, no, if we need to understand technology and to work with law, and we need to know a lot about the technology, I mean, we also have the risk that then we miss the part of from the legal theory perspective, you know, to really know and understand how that works. So I think it's a matter of just gathering the right people around the table and finding a common language. That takes time. That takes time.
And maybe regarding the second question, I mean, sure, we always have that issue that, I mean, why is, for example, any regulator or the lawmaker the better one to determine what is good or what is actually kind of something that we want in a certain market? This always, and I mean, going back on a more theoretical level, I mean, this is clearly why also we completely adhere, or typically under general like liberal ideas of how you should kind of design markets, we typically abstain from market intervention because we think economic actors can do the job very well by just simply saying, all right, I want this, you want this. In the end, this is clearly what creates the most efficiency. Sure, there are failures. I think this is also what is extremely tricky. I also see a lot of issues if it comes to the enforcement level, because maybe if I'm a consumer, I have a portability right, and I then go and say to Google, please provide me with all my data, and I get a weird Excel file with a really random set of information, I might not even make use of it, right? So in these cases, I would simply don't know whether now Google is actually complying with its obligation or not. So here, of course, this is again one of it goes back to the pretty kind of theoretical idea about market regulation, where I do think that, yes, it is difficult. We should not lose the ties also then to the private actors, because they pretty much know what they want and where potential impediments are. And we should definitely not stifle innovation by creating too static rules.
Yeah, thank you so much. I think the first answer to your first question, to the first question I posed is quite indicative of like an interoperability issue at the human level, at the scientific level, and you just try to talk those through. I think it's interesting, for example, Jörg, in your area of expertise in law, over time, even in my limited time, I've seen competition law focused researchers become more and more fluent in, you know, of course, as law and economics was the dominant approach, then you had more and more people getting economics masters or PhDs. So you saw that coming on. And I've seen in the past couple of years, people coming to law with computer programming skills or autodidactically acquiring them so that they could be more fluent in the language, which was what was interesting. Whenever I saw those people present, there was always just a huge reluctance from the predominantly legal audience to kind of engage or to take their research output and not kind of instinctively run away from it or instinctively kind of reject it. It calls for a lot of openness, I think, and going to it, getting people to kind of maybe submit questions is to say, you have to put yourself out there. I mean, this is a complex area. Jörg and Bego don't have all of the solutions. They've outlined some of the considerations, and I'd love to see some of the MIPLC students especially submit questions, because I know you have them. I do think what you said at the very top, Jörg, you said, the red line is kind of hard to find. And I think, because given the complexity of this area, for my second question, or actually the very first thing that I wrote down was, okay, you have these mandates or goal stating of access, portability, and sharing, right? And then you have this kind of very vague language, if at all, in the recitals. I think in the paper you mentioned, it's in a recital of it has to be machine readable or in sort of like of common formats. In doing your research, did you come into contact with why they didn't give more detail? Was it apparent from the legislative history? Is it just apparent to you now why they might not have done it? They're afraid of the complexity and said, okay, let's just get these goals stated at first. We need at least that. What's your feel for those questions?
Bego, or
yeah, well, I can jump. It's an interesting question, because that's actually where we're trying to, this table that Jörg showed, this is how the starting point of our second paper began, and that's what we're working on. So trying to understand why in certain cases, and what we found is that, as we said, when they're trying to go into a more horizontal approach, these obligations are vaguer, so are more vague, because it's much more difficult to go into the imposition of technicalities when you're trying to go across all sections or sectors. While when they go into sectorial approach, the lawmaker tries to be a bit more specific, and even within that there are different levels. So what we have seen, there is a long history. If you look at the INSPIRE directive, we need to go back to almost 20 years ago. So it has been increasing, and that's why it has moved into this fourth level. But it has, the lawmaker tries to be very cautious. That's at the European level, that's what we have seen. And still, it's very difficult sometimes to judge, because by imposing these obligations, you also don't want to. That's, I think, our feeling. You need to be careful with what kind of market intervention you're aiming at, and if there is no market failure, and then you're in the risk that by setting certain standards, you're already hampering the innovation in the market, and at the end the welfare. So that's why it's sometimes, and I think it also shows this. It's something that we can see also in the data strategy of the European Commission, and I think that they have already outlined that, some of the commissioners, when they talk about these acts, that they are trying to be. It's just a first step, so we cannot expect everything to come out of this Digital Governance Act or Digital Service Act. It's just putting the first milestones, or putting the first stones towards building up something or going up in the ladder. But this is going to take some time.
Yeah, and if I may have a go on this, I think it really depends again on the case, right? Looking at sector-specific regulation, what you do assess is that some of the laws simply just reflect on the current market status, right? So in some markets, we already have quite nicely defined standards, also if it comes to data sharing. The banking sector is one of these examples. We always had a huge interest, private interests of banks sharing information, and it was even under 101 and in the ASNAF Equifax case, where the Court of Justice actually said that, yeah, maybe we have a 101 issue in these cases. So here, sure, the banking sector somehow already worked on that. We also saw it that this is always something that, I don't know why, but the financial sector is always a role model for so many other things. But here we clearly had that open banking approach in the UK, for example. So it stemmed from the Consumer Markets Authority, that actually investigated the market back in 2013, if I'm not mistaken. And then, of course, they came up with certain behavioral remedies also with regard to that. And from that on, we also saw that, of course, I mean, they pretty much just reflected on the existing market structures, also on the existing standards that were there. With the cars, we see similar things where we now have a new regulation in place, where we saw that the old one from, I think, 2003, or like an early one, was simply not up to date anymore, right? We are now looking at IoT cars. We have different kind of data models and data standards and also different kind of competition issues if it comes then to efficiently reaping of the further use of data. So here, I mean, this is exactly what is needed. I think on a horizontal level, we can't even go up with anything else than just mere general applications.
We have a question. Thank you, Niklas. He saw the brief mentioning the Inspire directive on one of the slides. Do you see a practical way to take public goods into the equation when it comes to finding a normative framework for API provisions? Could creating APIs for such information, which is to be provided by private law entities to the state, serve as a starting point?
Well, I mean, at the end of the day, it's not a matter of, I think, creating APIs, it's a matter of designing. And I mean, the Open Data Directive, it's a good example of, I mean, they already the PSI, public sector information, when it was reviewed, and now it's named after Open Data Directive, they start including much more requirements on how APIs, or what kind of information of an API needs to be there and share and open. So it goes into that direction. And as Jörg pointed, in the financial sector, I mean, it has, I'm not sure if, I mean, I'm right to say that it seems that even the Open Data Directive has taken some learning experience from the financial sector. I mean, because it's incredible how you see what things from the PSD to, or things that in the financial sector has kind of moved into many other areas. And in the case of Inspire, I mean, it's same as in the ITS directive. It's impressive how by taking very small steps, they have, I mean, we cannot lose focus on what we're talking about here. So we're talking about member states needing to create certain, what it's called in the Inspire language, a kind of group, so a certain entity, and that works from member state to member states. Not all member states have the same resources, can dedicate the same, so same happens with the ITS system. And still, I think the approach taken is very smart. It goes into tiny steps, but it aims at kind of pushing, no, into everyone needs to jump at a certain point. We see that from a private or even, I mean, I will say a hybrid point of view, because Gaia X is an initiative that also seems to go into that direction, but they have been bolder. I mean, the German and the French governments are behind. Fraunhofer had one of the main design ideas in terms of pushing for this semantic interoperability from the very beginning. So they already are giving you what are the requirements for API. So it's not that they are telling you how to create the APIs, but they're giving you certain ingredients that are must or necessary to include if you want to be part of that group, no, or that environment. And I mean, that's, I think, the reflection of this hybrid approach, no, which we think it's a smart move forward and can actually tackle kind of good or better these huge problems.
Thanks for the question, Niklas. Thanks for the reply, Bego. Next question from Oboka, a member of the class, MIPLC class of 2021. In your opinion, and in light of the dominance of the big tech data companies such as Google, Facebook, etc., do you think it is too late for application of competition laws to deal with issues of data privacy and management, given that the users are addicted to their data technology and have no bargaining power against the tech giants? An attitude of use me or just don't. When thinking of the answer, think how EU has struggled with taming Google on data issues within the EU. to either one of you.
Jörg, do you want to take, because I know that, I mean, he has written a fantastic paper together with Omar that if you haven't read it, it's on concurrences that you should very recently. And he has been analyzing the Facebook case. So I think that he's the right person to.
Yeah, sure. Thanks a lot, Averka, for the question. I mean, it is actually the most prevailing question that currently haunts all the competition kind of peeps in their dreams currently, right? I mean, how to tame the big techs. I think now with the Digital Markets Act, we kind of have a tool that already really abstains from these traditional competition policy considerations. We don't have any efficiency defense in these cases anymore. We have early on remedies that are actually designed to work from an ex-ante perspective. You also outlined that. I personally think, yes, I mean, it's a good way forward. We need to react. We kind of need to have a faster and a more flexible solution from enforcement bodies in these cases. And I think this is why also self-executable norms in these cases are extremely important. We should not really go with these long-lasting kind of competition interventions from regular, like from competition authorities, because simply it takes 10 years, right? Mm-hmm. Now, from a privacy perspective, I personally also think, I mean, what is the right approach? Yeah, in the end, we clearly see that the demand side is not really willing to value privacy that much. It comes then the question whether we want to go into paternalistic regulation in some way, right? Where the state actually dictates whether you need to value privacy or not. Here, however, we clearly see that a lot of people are just simply clicking yes, and they're happy to share their data, and they don't really care. I think it's tricky. I think the DMA and also the Digital Services Act, they provide great remedies on that. It's still a bit of a mixture of everything, and we're lacking clear, also like the clear legal rationale behind that in some cases. But I think, yes, it is a wonderful and a quite innovative way to actually look at it, and market regulation is tool. And also an ex-ante perspective is key. We also have that in the 10th Amendment now of the German Antitrust Act.
Interesting to know what's haunting competition law experts in their dreams these days. Data privacy, data sharing. I would say I just would like to thank you both. I think that's a good question to end on, and we've gone now for an hour and a half. So I think that's a good point. Really, thank you so much. I would recommend to everyone who hasn't already downloaded the paper on SSRN to download it. And there will be a follow-up paper coming soon. I'll put the pressure on you. Any date of publication?
Yeah, don't take me on that one.
2021, sometime in late 2021, early 22. I know how busy you are, so I don't want to put pressure on you, but thank you so much to both of you. Thank you for everyone for attending. We will make the slides available to you, I believe, and we will be posting this to our YouTube channel. If you haven't visited it already, please do. We have a couple interesting videos there for you. Thank you, and have a good rest of the day.